Our topic this evening, on which Barrett Prettyman will speak to us, is Jackson Unpublished, a story of Justice Jackson's participation in the deciding, the complex behind-the-scene deciding of that very important American constitutional law landmark. E. Barrett Prettyman, Jr., Jackson Unpublished.
Thank you, John and Greg and my fellow clerks and all the rest of you who've been so hospitable the last couple of days to us and have made this such a fine and fun series of events. We really, really appreciate it. Those of you who are familiar with Justice Jackson's unpublished opinion in Brown versus Board of Education, and I assume there are very few of you, may have wondered why he so readily joined Chief Justice Earl Warren's opinion in that case. So I thought we would explore that tonight. I apologize in advance for such a serious after-dinner, after-drinks subject, but I do think it's important at this place and this time that we understand the Justice's mindset just prior to his death. Commentators, including the estimable Richard Kluger, have all referred to his unpublished opinion as a single document. In fact, the Justice began writing it as early as the end of 1953, and on 5 separate occasions thereafter rewrote and expanded the original draft. Let's put these drafts in context. The first oral argument, as John has said, in Brown took place in December 1952. I became the Justice's only law clerk in the early summer of 1953. In September, Chief Justice Vinson died, and 3 weeks later, Chief Justice Warren took a recess appointment. The second oral argument was on December 8th of that year, and Justice Jackson began writing the first draft of his own opinion, voting to rule school segregation unconstitutional the day before that second argument. What was his state of mind at that point? It's fair to say that he had little reason to believe that the confusion which had attended Brown during the Vinson years had dissipated. He assumed that most, if not all, of the justices would be writing their own opinions. He certainly believed that there would be dissents, and he was fearful that the majority would place blame for the past on everyone but the court itself. To continue the chronology, the Justice repeatedly made changes in his draft in January, February, and March of 1954, and then on March 15th, for the first time, gave to me for comment what turned out to be the final 23-page version. I wrote him a frank and very critical memorandum. I typed it myself, and I must confess that in my naivete, it never occurred to me that anyone would ever see it except the Justice. My main problem was that the tone of his draft was so negative and even confrontational that I thought it would give voice to those who opposed the court's decision. Don't misunderstand him. He was not negative toward the result being reached and overriding the Plessy versus Ferguson, but rather toward how he assumed the majority would frame its opinion. I'll come back to that in a moment. On March 30th, 1954, 2 weeks after his last draft, Jackson had a heart attack and was hospitalized. At this point, he had not shown his draft to any other justice. I was there in Doctor's Hospital when the new Chief Justice brought Jackson a first draft of his own Brown opinion. I waited down the hall while the two talked, and after Warren left, I read the opinion. Justice Jackson, although disappointed that it did not rely on more law, seemed overwhelmingly relieved that it contained none of the attributes he had feared, and delighted that it was an opinion he could join. He had me type up a paragraph as a suggested addition, but the Chief Justice subsequently rejected it for a very good reason. The paragraph could apply to segregation in general, and the chief did not want even to intimate that segregation would be struck down in areas other than education. He was, you will recall, a consummate politician. At Jackson's suggestion, however, the chief did add this sentence to the Brown opinion, quote, "Today, in contrast, many Negroes have achieved outstanding success in the arts and sciences as well as in the business and professional world," unquote. Now let us return to Jackson's own draft opinion in Brown to try to determine his views. The most important point, of course, is that he was prepared to vote with what he assumed would be a majority and strike down segregation in the schools as unconstitutional. He was drafting, in other words, a putative concurring opinion, although it sounded in part more like a dissent. What worried him the most was that the court would blame the South or the schools or the lower courts for segregation when they had all simply been following what the Supreme Court itself had explicitly ruled that they could do: segregate on the basis of race so long as facilities and opportunity were equal. He was also worried that the court would act by fiat without any legal basis whatever. Very near the beginning of his draft, he wrote, quote, "However sympathetic we may be with the resentments of those who are coerced into segregation, we cannot, in considering the recasting of society by judicial fiat, ignore the claims of those who are to be coerced out of it," unquote. Thus, one may well ask why Jackson was so willing to join the Warren opinion when it differed in several material respects from his own views. The Warren opinion, for example, treated the history of the 14th Amendment as equivocal, whereas Jackson thought it quite clear that the framers did not intend to wipe out segregation. The Warren opinion relied in part on sociological studies that Jackson apparently thought were not a proper element of equal protection. And most importantly, Warren based his conclusion primarily on the harm that segregation did to Negro children, whereas Jackson based his on the disappearance over time of any claim that the two races were constitutionally unequal. I think the answer to why Jackson was willing to join Warren despite these differences is that Jackson liked the simplicity and directness of the Warren opinion. He thought even laymen could understand it, and as I have said, he was gratified that it did not place blame on anyone. And remember, unanimity of the justices was not yet realistically expected. The memorandum I wrote in response to Jackson's draft opinion took issue with several of his points and with the draft's structure. Richard Kluger, in his splendid book, Simple Justice, gives me credit for Jackson's decision to write no more. But another contemporaneous memo I wrote indicates that Jackson fully intended to redo his draft, but was interrupted both by his illness and by Warren's opinion. In any event, as you all know, Jackson joined with the other 8 members of the court in the unanimous Brown decision. In an otherwise very fine article in the 1989 yearbook of the Supreme Court Historical Society, Jeffrey Hockett concludes that, quote, "Jackson's argument for ending segregation was less susceptible to criticism than Warren's," unquote. While no one admired Justice Jackson more than I did, I have to disagree with this conclusion. The Justice's final unpublished draft opinion was well written, as one would expect, clear, lucid, and fully cognizant of all the problems attending the rational resolution of the cases. If anything, however, it was too forthright in light of the people it was trying to reach. Not only would it have been attacked, as Warren's was, but many of its points would have been used by segregationists to bolster their cause. This may have been one of those very, very rare occasions when it was to the nation's interest not to have Justice Jackson fighting for the court. And I really think Robert H. Jackson would agree with that conclusion. Thank you very much.
Wow.